drinking water supply of the United States, all who use public water supplies are at risk. It's this pervasive, slipshod attitude set by two of the most important U.S. government officials responsible for protecting the health and safety of public water supplies that in no small way contributed to the latest in a series of public health disasters, such as the recent boil water order for the District of Columbia. Yet for true scientists, such as Dr. Joseph Petruvo, who's still head of the Criteria Standards Division at EPA, I am absolutely sure to this day that none of these things would have happened. The second and an even more frightening aspect of my case is the role of the Office of Inspector General. It would appear, based on the documentation produced by the Inspector General, that they were working for the benefit of several chemical companies. It is clear that the initial investigation was initiated after complaints were voiced by a large chemical company. That occurred in April of 1988. The evidence gathered by the Inspector General's office shows unequivocally that by the end of May 1988 there was absolutely no basis for any of these charges. Yet they persisted.
Fighting the federal government is by no means an easy task. In my or any other whistleblower's case, you face an implacable foe who has unlimited resources. In EPA's case, once their lawyers become involved, they will fight on to cost the whistleblower as much money and take as long as possible to draw out the final verdict. Since they have jobs, the lawyers have jobs, and their job depends upon not winning or doing what is right, but on fighting, they will fight on forever, justifying their need to be on staff to continue that fight. It is a vicious circle in which the costs to the taxpayer are never considered. Once the Office of General Counsel knew that the case against me was bogus and unfair and without merit, they proceeded with it anyway. It is true that justice grinds exceeding fine. This process takes time. In my case, and in all the others that I'm aware of, there is a prodigious loss of income. My family suffered mightily. Initially, there's an embarrassment of being fired and having to explain time and time again that this action was wholly unfair and why it was unfair. What tried my patience and grated on my nerves is that in general, the benefit of the doubt was given to the government. Secondarily is that every potential employer in the metropolitan area was afraid to hire me because, and I quote, a substantial part of their business is conducted with EPA and they do not want to anger the hand that feeds them, unquote. What's an innocent person to do? His means of livelihood is snatched from him, an expensive lawsuit will surely follow. Inevitably, bills arrive. Mortgages must be paid, college fees must be paid, and suddenly the income necessary to pay all these expenses is absent. That scenario frightens even the most honest and responsible federal worker. And well, it might, because it happened to me and my family. Injustice to me and my family was particularly hard. My daughters changed their plans for an education. My older daughter had to postpone her plans for medical school until the money could be found to pay for it. My health suffered. My blood pressure went up. I gained weight. And I developed chronic irritable bowel syndrome. My wife's health was affected. She could no longer sleep. She constantly worried about medical coverage after the COBRA ran out. And she, determined, privately financed health plans routinely would exclude her because of her history of breast cancer. And if coverage were offered and at astronomical prices, a recurrence of breast cancer would be excluded from coverage. Her stomach was constantly in an uproar. But what of the scientists who are timid and who feel that their first loyalty is to their families? This is the chilling effect that my experience at the United States Environmental Protection Agency has had on my fellow scientists. How can the public be protected when the people charged with this mission are afraid that telling an unpopular truth, or as in my case, Writing a position paper that does not conform with already established policy results in their firing. Let me tell you a story. Only 2 weeks ago, I received a call from an EPA friend, a fellow colleague, an internationally well-known colleague and respected scientist. My colleague told me that recently compiled data shows that one of the causes of breast cancer is an increase in a particular enzyme in breast tissue. Furthermore, it has been shown that some well-known pesticides cause between a 4- and 8-fold increase in that tissue and that enzyme, and therefore may contribute in a substantial way to the epidemic of breast cancer now occurring in this country. My friend said, "Bill, will you please put your name on that paper, because if mine appears, I'm afraid they will fire me. I'm afraid they'll fire me. I'm afraid they will fire me." Let those words ring in your ears. I have a personal interest in breast cancer because my wife had it 11 years ago. I have 2 daughters who are at risk, perhaps because of these pesticides that are in the food chain. But not only my wife and daughters are at risk. Our mothers, our wives, our sisters, our daughters, indeed, all the women in the United States remain at risk. I'm afraid they will fire me. This is what has happened to the scientists at the United States Environmental Protection Agencies, whose conscience dictates that they honor their oath to serve and protect the U.S. public, but who also know that they need to keep their jobs, and who know that being fired by the government means that they may never work in their chosen field again. I want to say this again. The Secretary of Labor has issued an unprecedented rebuke to the Inspector General's Office of EPA. But more importantly, nobody at EPA has taken any remedial action concerning the illegal and felonious activities by the representatives of the Office of Inspector General. I would like to ask all of you gathered here today to ask Carol Browner, the Administrator of EPA, and Kimberly Tilley, Deputy Chief of Staff for Strategic Planning at the EPA, why they depend upon an Inspector General who himself has been singled out for criticism in one of the Congressman Dingell's reports, and who encourages and rewards such licentious actions. These actions which ultimately tarnish the United States Environmental Protection Agency and cause our agency to become suspect in the eyes of the very public that they are there to serve and protect. Thank you.
Her stomach is still in an uproar. I think that it was easier to go through breast cancer than it was the past couple of years because there was no stigma. There was no real stress tearing the family apart, and at least we had an income and health coverage. It's easy to see how people can go from being in a position of relative security to complete insecurity. That's it.
Rufus.
I want to congratulate Steve, and particularly Bill and Elaine, who have we've all been through this process for it seems that it is almost interminable now. I also want to follow up on Bill's remarks about the Office of the Inspector General, which turns out occupies about the same place that one would comfortably place the Gestapo in Nazi Germany. They are the enforcers of the political agenda at EPA. I've felt their sting for expressing opinions completely outside of the realm of EPA in my own community on my own time. So the rebuke to the Inspector General, and in my opinion, He has long since passed any usefulness that he may ever have had, and I think the Inspector General should be fired from EPA, and I think the people who have perpetrated these lies, the slander, the shredding of documents, the shredding of evidence, the alteration of time records for Dr. Marcus should also be disciplined, perhaps fired. I think it is a complete outrage on taxpayers to be supporting people at high salaries, any salaries at all, at EPA who are given the mandate of protecting the public health and the environment. They seem to be more interested in protecting industry, according to our what we found out from Dr. Marcus, than they are in protecting the health and welfare of the public in this country. The last thing is that I'm no longer associated with the union, and I wanted to make that clear.
Thank you for coming. My name is Michael Cohn. I'm the General Counsel for the National Whistleblower Center. The center is located in Washington, D.C., and is dedicated to protecting whistleblowers in the United States from harassment and intimidation. This case, when first brought to the center, was one of the most troubling cases that has ever come to us. A document perhaps 3 feet thick was piled on and said, this is the basis of a legal termination, a 4-year critical investigation compiled by professional law enforcement officers of the United States government. And we looked at that pile and said, how much resources can it possibly take to go through this and figure out what's really going on here? And the center, with the help of numerous law clerks, spent countless thousands of hours to try to put these pieces together. And without the help of the center, I'm sure Dr. Marcus could not afford those legal bills. The fact remains that under close scrutiny, the truth came out. The report contained falsified information. And then when we got closer to the heart, the documents started to be shredded that would really start showing what was really going on within that agency. But with the records that did remain, it was clear the investigation was begun at the behest of one of the largest chemical companies in the United States because they were afraid Dr. Marcus would testify against them in some civil litigation. As a result, eventually, I should also point out that Dr. Marcus was very instrumental in providing key information to congressional subcommittees that were looking into specific information. And when they found out what was going on, they suspected there may be some wrongdoing, and the chief investigator for that congressional office contacted the Inspector General's office and said, we want to know what's going on. We're going to be investigating. At the same time, they knew Dr. Marcus had filed a civil lawsuit, and they knew Dr. Marcus had filed numerous Freedom of Information Act requests covering this documentation. And their response was shred, shred, shred. That's criminal, and that should not go unnoticed. The Department of Justice should take notice and investigate and let justice be had. Moreover, the person ultimately responsible, John Martin, the Inspector General of the EPA, should be called and put on the record as to why this was allowed to happen under his watch. And it should be noted that this will not be the first time Mr. Martin has been called before Congress or other bodies and questioned about improprieties associated with his office. It's time for his removal. It's time for the Department of Justice and the Clinton administration to move swiftly and remove people from office who can allow such criminal activity to proceed. I think it would also be proper to send a message to the other Inspector Generals across the United States and each of the other agencies that the agents should be disciplined and perhaps, if they engage in criminal misconduct, prosecuted. And that is the only way to start making the other agents and the other Inspector General's offices aware that this type of conduct cannot be tolerated. And if the message is not sent home clearly and loudly, the infection will spread, and other investigative agencies of the U.S. government will begin producing bogus reports and attempting to attack those who they feel are otherwise defenseless. And I want to point out that Dr. Marcus was defenseless, and by sheer luck, he was able to find the resources, or have other people find the resources for him to put together his litigation. And that is providence. Thank you.
Just before we start the question period, I would just like to point out that the significance of the decision applying the 6 whistleblower provisions of the environmental laws to the EPA is evidenced in the outcome of this case. Without the type of procedural rights afforded under that law, such as subpoena power, the right to do depositions, the type of rights that private sector individuals normally have in litigation, most of the facts would never have surfaced, and Dr. Marcus, I believe, would not have obtained justice. And what we're hoping with this decision is that employees become aware of it and start using it as a very important tool of environmental protection. With no further ado, anyone from the press who has any questions should feel free.
Is this the final step, or can they appeal further?
This is a final enforceable order of the Secretary of Labor. If EPA were to appeal it, the order would still be effective, and Dr. Marcus would still have the right to return to work and obtain his back wages and damages. This is not an interlocutory decision.
Okay. Is there any way to know when he might be able to return to work?
We hope to work that out within the next 10 days. I don't know what the agency's position will be, but if they don't return him to work under these laws, we have the right to go to federal court for a contempt citation, which we would seek, and if the administrator did not return him to work, we would seek to find the administrator in contempt with all the sanctions that are available, which include civil fines and imprisonment. But that is one of the differences with these environmental statutes. It gives us the right to go to federal court and to seek contempt if someone does not comply with the order.
How has Dr. Marcus been paying his bills for the last couple of years?
How have you been paying?
How have I been paying my bills? I've used 3 mechanisms. 1, selling my assets. 2, working as a private consultant and an expert witness. And 3, some of the bills have been that I have gotten with friends have been put aside till I can finally obtain my back pay.
Well, one of the biggest issues in this case was the stripping of the Marcus family's health insurance, in which the problem that they came into in that one is because of pre-existing illnesses and their status, substitute insurance was impossible. We moved the agency. We went to the EPA and said, look, we've won at the lower levels just before the secretary, keep his health care going. They said no, and they stripped it.
They have to reinstate it.
Yeah.
As though it had not.
That's right. What's the decision returns Dr. Marcus to his position with all back pay, all the privileges of employment, plus it gives him $50,000 for the emotional distress he suffered, which is also the highest emotional damage award the secretary has upheld to date. And it also will pay him back for all the attorney's fees he had and all the costs that were incurred in pursuing the litigation.
Most importantly, EPA resents the fact that the judge required that the order be posted in a prominent part at EPA.
That's correct. So under this law, they have to take Dr. Marcus's reinstatement order and plaster it not only throughout the entire EPA.
Is that environmentally sound?
Yes.
Does this ruling affect other federal employees that are not working in environmental positions, or is it just folks
The ruling clearly covers all EPA employees, and if you read the decision, it also covers all federal employees, but only if they blow the whistle on an environmental issue. For example, if you work for the Department of the Navy and you witness illegal dumping of a chemical, you can file the suit. In other words, your status is irrelevant. These laws protect any employee in the United States, private sector, state, and now federal, who witness a potential violation of the environment and disclose it. In practical application, this will have a major impact at the EPA, because there are other whistleblowers there. And now they can seek, and it's been clarified that they have the protection, and we view it as a major landmark decision for that reason. But it covers every federal employee in the United States, but only if they disclose a potential violation of an environmental problem. If they blow the whistle on some other matter, they can go back to merit systems.
You know, this has been a big issue in the nuclear business, with how whistleblowers are treated for raising safety concerns. And I'm wondering how this might affect them, even though they may raise issues regarding safety. I mean, with nuclear power, it ultimately affects the environment. I wonder if this really will have any effect that way.
The 6 statutes are very similar to the atomic energy statute, but with one difference. The atomic energy statute is a little narrower on who employees are. And although there could be an argument that this should cover atomic energy, it's not clear. It would have to be litigated. But however, if an NRC employee disclosed a violation that would be appropriate under the Clean Air Act, which also has jurisdiction, or the Safe Drinking Water Act, they can use those laws. So if there was a threat to say that radiation would be leaked into the water system, they can use the Safe Drinking Water Act. In other words, so it doesn't matter what agency you work with, you're covered. But some of the problems that they have in NRC, our investigations have shown EPA is 10 times worse. Their record on whistleblowing is even worse than NRC's record.
You mentioned filing a suit as a witness to some sort of environmental crime. One particular thing comes to mind with the EPA. Unions that involved in the agency conducted a study of indoor air quality. They found a statistical link between carpet odor and adverse health effects. They sent out public information saying there's no scientific link between carpet and adverse health effects. Does this constitute a violation that's actionable in your view?
What would occur is these laws would protect you. Let's assume you raise that concern. An EPA employee raises that concern with a supervisor, and then the supervisor retaliates against that employee. Then they would be able to use these laws. These laws don't solve the actual environmental problem. What they do is they allow employees, and now federal employees, the freedom to disclose the information. And now you may say, disclose it to who? Under earlier precedent of the Secretary of Labor, who you disclose the information to is broadly construed. It's not just your employer or your supervisor, but there are cases that say if you blow the whistle to the news media, you are fully protected. So these statutes give federal employees not just the right to go to the IG or their agency, but they can go to Congress, they can go to the press, and they will be fully protected under these laws. Any additional questions? And any questions for anyone on the panel? Okay, if there are no further questions, the individuals here would be available for one-on-one interviews. Thank you very much.